Yeah.
Yeah. So this way, we will try to bring clarity about association registrations, high court decisions on association formation. All these details will be covered in this seminar. So now we will start the seminar with introduction to Gautam sir. Gautam sir has audited almost has done civil audit with more than 30 plus associations all across Bangalore, and his largest RWA being Prestige Jindal City. He has successfully done civil audit, done preventive audit, and helped all RWAs for future risks which they are going to face because of the builders' deviations made while constructing the apartment. All those things have been brought forefront to the notice of all residents, and many future discrepancies are prevented by him. So this way we will learn from him about the audit process, what all things to be taken care when you take handover from the builder. So I will hand over the stage to Mr. Gautam sir. Welcome, Gautam ji, where we can uh, have the knowledge sharing from your side. What is required for an apartment complex on the audit part?
Thank you,
Yeah,
Abhilash.
thank you.
Let me give a brief background. I am Gautam Kamath, a mechanical engineer. I have worked in water treatment company Ion Exchange India Limited, as well as Tata Consulting Engineers in the building sector, where I was involved in putting up projects for greenfield projects for Wipro, TCS, Bosch, and educational institutes like IIT Hyderabad and BITS Pilani. So my background is that. Then I was the founding president of Liberty Square Apartment. I have gone through the role of treasurer, secretary, and I was the Bangalore South cluster president for Bangalore Apartment Federation. Maybe some of you are members of Bangalore Apartment Federation. For the term 21-23, I was the Bangalore South cluster president. So all my experience in this building issues I'll be addressing today in the presentation, where basically I'm addressing the handover takeover process, which will be of interest to all of you and who have already taken over. Maybe other things like the licensing and all other aspects which I'll be addressing will be of interest. So I'll run through this PPT, explain that. We'll have a question and answer end of my session, maybe 20 minutes for the presentation, then the question and answer. So let me open the presentation. Just hold on. Can you, hello, Abhilash, can you see the screen? Can you hear me?
Yes, sir, I can see. Yeah.
And you can hear me also. I think
Yes.
everyone can hear. Yeah. So
Yes.
basically, I'll run through the thing. In a building, which apartments which we are going to take over or take the assets into the our association or RWA control, we have three major or four major issues which comes into picture. One is the title deeds of the land and related documents, the GPA, all these. This is the first set of things which an association should mandatorily do audits to see that the things are in place, because the asset what we are going to take over, the land, the building and all, has a life of 50 to 100 years. So for a period of that, this has to be done. This is done by the lawyers who do the due diligence maybe up to 50 years before the project is done. So that may be from 1950s or 40s or 60s, 70s, depending upon the documentation. So this is very important. Lawyers do this, and Abhilash is one person who can take care of this, because that's a specific job of the legal thing. Then comes the important thing in an apartment is the compliances to the sanction plan, the NOCs and licenses. Now, every building has a sanction plan, and the sanction plan is based on the NOCs issued by various departments. And at the stage of OC, licenses are obtained and then OC is given. Now, this is where the architect and an engineer who have worked in building field into specific building field come into picture to do the audit or due diligence. Next thing is the utilities. Each apartment now has utilities for which we do the checking. Utilities are there. Then what do you have? Drawings are required. Installation needs to be checked, and then the operation and maintenance. When we tell installation, it is both the civil and the electromechanical equipments. So what do we need for that? Is base is the drawings to do that. So who can do this? An engineer can do that. Then the last part is an association when it takes over. There is an issue or main issue is the finance if corpus and CAM things are to be audited. That will depend on what is the agreement with the builder when the sale deed was done or corpus was taken or not. Now, coming to an audit, why an audit is required? See, we have been hearing, reading newspapers where a lot of deviations are there. Just the other day, you must have heard that one tower has been, High Court has asked the Platinum City to demolish one tower. So this is where the issue is because they have deviated from the sanction plan. So an association when takes over should be aware of the deviations if anything is there because that will lead to future legal and compliance entanglement. So that Platinum City is a compliance issue. Then financial impact. Because of these compliance issues, now financial impact may come on the association or on the builder itself. Now, Platinum City, the court has told the builder to demolish and compensate the existing owners according to today's rate. Then all this leads to mental stress to a resident or an owner. Who is now taking care of the owner? The association RWA, AOA comes into the picture of this. Then comes your equipment. There are a lot of equipments, water, then you have lifts, you have other electrical systems, whether safety and compliances are there for that because there are certain rules and regulations for each of them. If safety and compliances are not there, there could be damage to property, loss of human lives. We have heard a lot of human life damages happening in the last couple of years in the newspaper. Overall, the audit should lead to overall life, enhance the overall life cycle of the project because you identify the deviations, deficiencies, snags, get it rectified from the builders because every one of us has paid a good amount of money to get a property which should be very good to last more than 60 years with minimum maintenance. So the quality of workmanships come into picture. Now, when we get into audits, let us not be bogged down by the word of audit because that's a very huge subject. But as an apartment, as an owner, as an RWA, we should look at certain audits like when the association is taking over the assets or the building or the record from the builder, does the association members have themselves the capability, knowledge, time to do that? If they have that, they can do it. Otherwise, try to engage an external agency who can do that. Then what do you audit? Now, audit should be as per whether the whole building, the complex is been done as per statutory norms because there are NOCs and licenses which are coming next. Then because statutory norms like in civil in Maharashtra and all, at the end of the 30th year of the building after OC, it has to be structural stability certificate has to be submitted to the municipal corporation. Lift renewals, they ask for stability certificates. So not just one equipment, but the whole building is also audited that time. So then there could be some vendors who tell that frequency of audits. This needs to be got from the vendors. Then as an association to keep the building or the assets in good condition can themselves plan monthly, quarterly, half yearly or a yearly audit, internal audit or external audit. Then there could be an emergency audit required. Some major crack has been observed in a column or a beam. Then you need a audit for that. A third party audit will be required who have good experience in that. Who should be an auditor is very important because auditor is a very experienced work who should have good experience in that. And basic thing is he should have educational qualification. Now a civil engineer should do a audit of civil part of it. A mechanical engineer does an audit of mechanical things. An electrical engineer will do electrical part of it. So these are then we have architects who do the audit for compliances because if you look at it, your whole building is designed by architects, conceptual design. The services, utilities are done by the mechanical, electrical, and plumbing consultants. So you require a balance of these educational experience. Then professional work experience, I would always say engineers who have worked in the building field, they should do the audit. Not novices who have no just educational background alone will not be enough to do an audit, because audit is an experience. Then if they have certifications, if certifications are there, it's nothing like that. But today, to do a building audit, there is no certification issued by any government agency or anyone. However, when you look at an architect, the architect who designs buildings should be registered with BBMP. They are registered with BBMP, and those do the audit. That means they are well aware of BBMP norms, guidelines, NBC guidelines, everything. So the design, the verification can be done by them. Then next is the hands-on experience. Every one of you accept that if you have an experience in design, procurement, inspection, installation, and operations, that will help in the audit. The best part is if individually we have gone through the Hoto, whoever is doing the audit, because there is no theory for this audit, this is a practical experience. So if you have gone through a handover takeover process, it helps immensely. Next part is if you have been an office bearer, an MC member, nothing like that, because all the pain points you would have gone through and you would have experienced that during your period, that can come to your audit also input as an input. Now, each one of us is very happy when we see our builder says, I have got an OC. But most of us don't even read the OC. If you read the OC, you will see that your OC is conditional. The last line in BBMP's OC document, please read when you have go back and read your OCs. It reads the 16th, maybe the serial number may change depending upon the OC issued. In case of any false information, misrepresentation of facts, pending court cases, the occupancy certificate shall deem to be cancelled. So this is a very important line which we just read it and forget it. But this is the line which BBMP or BDA uses to literally threaten, blackmail us as individual that deviations are there. Now, what is OC? OC is issued based on certain documentations. This is the document which a builder has to submit to BBMP or BDA to get an occupancy certificate when the building is completed, construction is completed. Now, every one of us thinks there is a completion certificate. We must have heard the word CC, completion certificate. Who issues this? Most of the people think that completion certificate is issued by BBMP or BDA. No, completion certificate is issued by the architect of the project. Now, who is the architect? The architect is the builder's person. So they give a completion certificate. So this is the declaration document, which I was referring to in the previous slide, false information, misrepresentation of facts. So the completion certificate is issued by the architect. Along with other documents, the builder has to then submit the Khata extract, Khata certificate, current year tax paid receipt for the whole project, land. Then 3 licenses are mandatory to be submitted to BBMP BDA to get the occupancy certificate. One is the fire clearance certificate, that is, and the consent to operate the STP issued by Karnataka Pollution Control Board, electrical installation approved by CAIG. CAIG is Central Electrical Inspectorate for Government. So let us be very clear, DESCOM is the service provider, CAIG is a person who certifies the installations. So you have seen 3 licenses which are mandatory, and the 4th, though mandatory, sometimes they get it or not get it. Lifts. Lift also has to have license to operate the day OC is issued. Without a license, lift is operated, it is illegal. Any accident takes place, then you will not get any type of insurance or anything. Again, lift license, who issues it? CAIG. I'll come to the timelines also on that. Along with this, then all others are very generic. You have to put photos of the building, photo of rainwater harvesting system, waste collection system, solar water heating system, transformer yard, vehicle parking system. All these are all photos. If you finally look at it, one completion certificate issued by the architect, some photographs and some licenses, that is enough to get a OC. There may not be a requirement of physical inspection by BBMP or BDA. They just come for a couple of hours, roam around, and then go and issue a OC based on this. So please understand your OC is conditional. Don't be, we should be never complacent with OC. Just because OC is there, that doesn't mean everything is there. So finally, OC is issued based on declaration and photos. Hence, an audit is a must to verify compliance to sanction plan. NOCs. I'm coming to the NOC part. So audit is what? So we start an audit with the NOCs. The sanction plan is required. As-built drawings, because the sanction plan to as-built, there will be some variation. So that is also required. During as-built, these as-built drawings are resubmitted during OC stage and got approval. Many of you would have seen in your OC that there is a 5% penalty paid and to get the OC. Up to 5% deviation is accepted on the calculated built-up area. So they calculate the built-up area and show it less than 5% and get an approval. On the drawing, they show it and get a OC. Completion certificate issued by the architect, occupancy certificate, then the licenses, design documents, asset list. This is where it's more interesting or interest to each apartment association, assets and the O&M manuals and records and the drawings. Without this, you cannot do maintenance in bigger apartments. So which are the area of audit? So now when audit, we say auditor can do only the common area, because inside the house it will be typical. Common areas are not typical because we have different assets also in that, or utilities. So here we do the compliance to plan approval drawing, NOCs and license, whether NOCs are there, whether licenses are there, whether the compliance is building is done as per the NOCs. So which are the systems which you audit? One is the electrical system, from the HTR, transformer, DG to everything related to electrical, earthing, lighting, lightning arrestor. These are all covered, whether they meet your building requirement. Then comes the general safety audit, because the elevators and the fire protections are very important to the building, which we do the design audit as well as the design. When I say design, it's only the capacity, not the total design of the thing, whether the capacity meets the requirement of end for the project. So fire protection. Then another important subject is water, from borewells to the plumbing system. Borewell, if you have a WTP, STP, rainwater harvesting system, these are the systems which are coming under water. Then we can do, or an association can look at doing audits for swimming pool, solar water heaters, waste converters, rooftop solar, it is there. Rooftop to solar and waste and solar water heaters are mandatory requirements. Many of us don't know that solar water heater is a mandatory requirement. Rooftop solar has recently come as a mandatory requirement. So building civil works. So building civil works, when we talk about civil audit, see, basically these buildings are new, painting is done, and only a visual check can see, because construction quality cannot be challenged now. It can be challenged only when something exposes, like when you do an audit, if you find seepages, then dampness, then cracks. These are the only three major things which an visual inspection can tell that. Over the visual, you can go for further inspection if required, but why should a RWA spend on further inspection? Because the builder, if any defect is there, that is the job of the builder to rectify it, identify, go into the detail and do that. So these are the basic area of audit. Now, how do you do an audit is very important. One is, to do an audit, experience is required. As an auditor, if my team, what we do is we come to the site, go through the site, then ask for all the drawings, because we are engineers and architects. We review the drawings, we study the drawing in detail, then go back again to the site to see the compliance part of it. That's what I'm telling was the walk through the entire building to understand the nature of all the utilities in the building, installation compliances with respect to NOCs. I'm sure many of you would have seen the NOC documents given by the builder when you book the apartment, or it is not there, you'll have to get those documents also to read. Then the main another subject is data collection through discussion, past records, design, as-built documents and specifications. See, unless for an engineer, for any building engineer, for an engineer, the drawings and documents are the requirement. Physically, I can do an audit without anything, but the output may not meet the requirement. But if we have all the documentation given, then it gives a better audit report. Then we discuss with the administrative officers, operation and maintenance staff on operation and maintenance process followed. Here it is very important to talk to the operation field guys, because builders, engineers will hide all the things, defects or inaccuracies, everything. But the operation guy, the field guy in the field, like STP operator or a WTP operator, electrician, plumber, if you talk to them, they give all the negative feedbacks as well as positive of the project, so that can be identified. Because physically in maintenance you cannot identify physically anything, only the visual view can do, but internal maintenance things can be report can be got from the maintenance staff. No, though there is no written records, verbal information we can collect, prepare and discuss, then submit the audit report. So what is the audit output? Output is, the first output is whether the building built with all the utilities complies with the NOCs issued and the building is as per sanction plan. The OC documentation, OC has certain conditions written, whether that building meets the OC conditions and all other statutory norms. This is the main thing, because this is where the association should concentrate on, because every renewal, you are the people who are going to renew all your licenses. So before closing, let me tell you licenses. There is, as I said, one is for the STP, one is for the fire, one is for the lift, one is CAIG electrical and DG approval, and then there is borewell. So borewell is one another license every apartment should have. Then the next part, major part of the audit, is the design capacity. Now you have so many utilities. Do you know, are we sure the capacity of those meets your end requirement based on the National Building Code? Because water, it depends on the population. Then electrical will depend on what is the commitment given by the builder in terms of the kilowatt for each house and the common areas. So we look at those things into the audit. Fire system capacity, pumps and all, is meeting the design requirement or not there, because we have found a lot of deficiencies in design where the transformers are under capacity, which will not meet your immediate requirement at the end of the full capacity of the apartment. DGs are underrated, fire pumps are not in right capacity. These are the things which we identify, try to identify and give it, and then the builder can rectify that. The document adequacy for future needs. So you need to have all the as-built drawings in your custody, because a small apartment somehow you can do it, but if you have a 1,000+ apartments with multiple towers, unless the drawings are there, it becomes very difficult to do the maintenance and re-procurement of defective or damaged or broken down equipments also. So the whole documentation has to be given by the builder, which we give as a list during the audit, and that needs to be given by the builder to the association. Maintenance contracts. So association now, at the end of your 1 year maintenance period, takes over the whole utilities for maintenance. So the basically many times the contracts get transferred to the association. So the responsibility of RWA will be to look at all the contracts, whether they cover comprehensiveness. If it is not there, you'll have to amend the contracts or go with new contracts with new agencies. This needs to be looked at it. Operation and maintenance logbooks. This logbooks gives you the history. When we buy a second-hand car, we take a mechanic to see it, though there is no logbooks. But if you go to a authorized vendor's garage, they have all the maintenance. If the vehicle is only going to the authorized service center, they have all the data of it. So you get information on operation and maintenance. You are getting almost a 2-year-old building to your custody. So you will have to look at it as a second-hand building which is coming to your hand. Though it's not very old, but it's still a second-hand building. So for that, you'll have to audit and see that when you take over, your liabilities will not eat your funds. Quality of construction installation. Now, quality of construction installation, again, I would like to highlight here is the builder is getting the construction done from third-party contractors. During their final bills certification, the contractor, the builder has already certified the work and issued them the completion certificates. Now, whatever is coming out is during our audit is gaps in their own quality certifications. So that is the biggest issue. The quality has already been certified by the builder. He has given the money to his subcontractors. They have already walked out of the building after 1 year of the warranty period or defect liability period. So build, tying them up with new things to the builder is a challenge. However, if main things are there, you can always tie up with them, because RERA says now civil works, the warranty is for 5 years from the builder. And many of us know that waterproofing warranty is 10 years. So your waterproofing for terrace and your toilets and your basements, there is a 10-year warranty given by the waterproofing agency to the builder. So this warranty should be transferred to the association. How do you do it? It's a tripartite agreement, builder, the vendor, and the RWA. At certain stage, when the RWA takes over, the RWA has to, AOA has to insist on the builder to transfer these warranties, because otherwise we are not aware of it. Fourth year, there is a leakage, dampness and all, we go on spending money. So basically, what I have addressed is the compliance part of it. Even though you are a new building or old building, look at the compliances. If you have not taken over, even if you find a defect or deviation today, please highlight it. When many of you may have gone for renewal of your licenses, just a minute. I'm just closing the PT. I'm coming to the Abhilash, can you see me? Hello.
Yes, we can see.
Something you are seeing me, this thing, I think. Okay, just a minute. I'll have to stop share my. Yeah, so the licenses are very important for every apartment. 5 licenses. Please ensure that licenses are available. Ensure that you start the renewals at least 45 days before the validity period. Then there could be some licenses which are to be renewed every year, some every second year, some on the 5th year. The lift first time it is 10 years. So you'll have to look at the funding for that, what is required, your budget for that also. And these licenses are very important, because, and if deviations are there, what we have found, I have found personally also, is there are deviations which these agencies come and highlight during the renewal stage, and with a simple threat telling that OC is at stake. The minute OC is at stake means the building is illegal. So what do we do? So we know what we do is adjustments. So let us try to avoid all this by seeing that when the builder completes the project, RWA takes over, these compliances are met by him, and we insist on him or tie him up with future liabilities also. So tying him up with future liability is one thing which I'll be working with Abhilash, how legally we can do that also. So what I would request is, any questions are there, we can run through the questions. So Mr. Amrit has, yeah, Mr. Amrit can ask.
Yeah, thank you, sir, for that overview. I think definitely if this list can be shared, then many of us will benefit. So the first question I think I had was, now that, for example, my building, it is, say, in the process or already taken over, I'm sure many would have the same condition. Is there any post assessment that can be done, and is there any value in doing that? That is question one.
Yeah.
And sorry, and the second part of the question is to your last point, that now that handover has been taken, is there any way for, can we evaluate ways together for us to hold the builder liable for not on that? Yeah, those two.
2 questions what you have asked is handover has been done. What is handover done? The records, what I understand is only documents are given, right?
Yeah,
So you
that
are
now
only
the site is
signing it
maintained by
as,
our
yeah.
association.
Fine. So it's a process where the documents are handed over, asset is handed over, whether the asset list is done and assets are recorded and signed off, that is very important. See, what is happening today is we say drawings are given and handed over. Now, how when this was done? How long it is now?
Sir, as I said, 2020, I think
Okay.
2019,
So
2020.
yeah, I'll address in a way now. 2020 to 2024, your fire license would have gone two renewals. If you are a high-rise building, you are coming under fire,
Yes, sir.
so it is
And we
renewed.
did not know that the NOC is, like you said,
No,
NOC is out, and then we had to do it. Similarly, pollution for STP was
exactly,
out.
exactly.
Yeah.
That is where the problem is, because these are not recorded on day one, and builder simply hands over and runs away, doesn't educate you anything.
Exactly, sir. You're right, sir.
So this is where the audit comes into picture. As I said, there are 5 licenses. Please ensure these 5 licenses are live. 45 days before that, the renewal has to be done. Now, how to renewal, all those things are different subject, how to get it and all. But these are 5 things. Audit can be done today to look at the compliances, deviations and all. So, but builder is already 4 years gone. He is not there in the picture. Today, if you go and tell, he will say that I have already handed over to you. You should have come back that time. But during renewal stage, you may have issues, because we have found in fire licenses, every time they come, they find some or the other major deviations. And then you know what happens, the deals happen then.
Exactly, sir.
So how do we
The
avoid
deals are
this
what
with audits?
is actually costing us a lot of money, to be honest, because yeah, original builder did not tell us, and somehow we get notice is when we get to know. So not 45 days before, actually 30 days after something is expired is when we are getting to know.
No, notice is because, see, notice is not required to be issued by them. It is clearly in the license written that you have to process it 45 days before. It is the responsibility. Please read your OCs. It very clearly says it is the responsibility of RWA to do it. Government has no responsibility. If you have not done, they will ask, a notice will be sent, because they don't have manpower to do that. Everything is, that's the reason they are. See, let us be very clear. If my car driving license is getting expired, do I in advance go and do it? Personally, I do everything. For the association, there is no education done that. This is where the picture comes. Anyway, so please have a list of it, and all these licenses should be stuck in your RWA office, physically seen, or at least make a table and put it, so that when you hand over to the next MC, it is seen, everything is there. In our AGMs, in our AGM report, we record this. We present it, record it, validity is written in the AGM meetings. So please follow some processes which will help you to overcome the financial or legal liabilities. Yeah. Any question? Next question. Prakash, yeah.
Yeah. Good morning, sir. It's a very informative session. Just going through whatever you have talked, sir. Is there any successful case won by RWA in the event of half and half handover or incompleted work by the builder? Any examples?
See, let me address in a way where there are some associations who are fighting with the builders for all these deviations.
Yeah.
Now, after RERA, there is the apartments can go to RERA and put a complaint. There are a lot of complaints in the RERA which are going on, and RERA gives rulings on that. The main issue is deviations, which I am talking, no one is addressing that because of ignorance. As Amrit was telling, they were not aware of the licensing part of it.
Yes.
So these are the things. When the audit happens, when the renewal happens, people are coming to know the deviations.
Okay.
So that is where this audit comes into picture now. What we are doing in audit during the handover takeover, the minute the builder says, I want to hand over, before that the association forms an ad hoc committee, and that is the stage where the audits should happen, and builder should be aware that he cannot simply hand over the documents only and run away.
Okay.
Because today what is happening is he just gives a document, gets a signature on that, hand it over, finished.
Okay.
No, we as an auditor try to identify all the deviations which are there, record it, and so that the builder is aware. So he knows that, and now how to take it up legally is what we have to work with. Abhilash and myself will be working on it. If deviations are there, how do we tie up the builder for future issues?
Just a follow-up question on this.
Yeah.
is it the responsibility of only RWA or members of the association? Means resident members of the association also needs to be.
See, basically, members have authorized the association. Why the MC is there? MC is representing the residents. If residents have, if someone finds something, they have to bring it to the notice of the association. Association will be front-ending all the things.
Okay.
So the whole part is because association is authorized by, or RW is authorized by the owners to represent them.
Okay. Okay.
Yeah. So Dolly, we can ask Dolly to go ahead. Hello. Yeah.
So the question is,
Yeah.
In a B Kata property where you don't have plan sanction and OC,
Yeah.
how do you get the license for the lift, sir, elevator?
That is where the Bkhata, see, elevator license, you have got BESCOM power.
Yes, sir.
So similarly, see, because Bkhata is totally, the BESCOM is giving power because everyone wants revenue. OC is not there. So OC is not there means lift, all those things won't be, to my best of my knowledge, it's very difficult to get that. But individually, you can put an application and get it at least the lift license, because all these licenses pre-OC. Your main issue will be in B Khata, either the property is B Khata or the building is B Khata. There are two things. Property is not converted property. It's still revenue land. So that is B. But your building may be B because illegal construction is done. Now, illegal construction is done, lift license won't be given because one floor additional is built means lift has gone up one floor. They will not give a license.
So the building, the land is actually converted, but the layout is not approved. The building is constructed and, we don't have that license. I mean, electricity, everything is there.
Yeah, let me address it in a different way because I'm not an expert in that. If Abhilash can address that, nothing like that, if he has any knowledge on legal issues of
Generally, what has happened is if a building plan sanction is allowed, so a lift license will also be allowed. But if it is a like, let's assume it's only 3-floor building or 4-floor building, and builder has made a large number of deviation. In that case, he will install a lift, but he will not obtain license to run the lift.
Exactly.
So this way, in case of future any accidents or any other these things, loss of life or anything happening, in that we have to hold the builder accountable, and we have to run behind the builder for all such damages he has caused for running a lift without license and permits. All those
So,
things are there.
yeah, at that stage itself, you will have to, if you have created an association or a RWA, communication has to be put to the builder to get a license so that you are on the right path on that. Because
And also one more thing, if it's a larger tower, more than 6 floors or 10 floors, then definitely lift license is a requirement. Without that, they cannot construct at all.
No, sir, actually, this is just 2 floors, ground and first floor.
Okay.
Only
so
2 floors.
it becomes a personal lift type. So let us check. Let me check and come back on this. We'll
Yes,
keep
sir,
this.
it's actually personal things, sir, not
Yeah,
this thing RWA related.
I got it.
Okay.
Okay, we'll look at it.
Yes, sir.
So next is Nishita. Nishita, you can unmute and ask your question.
Next, Mr. Ramesh Rao.
Yeah.
Yes, sir. My question is, can you kindly repeat that 5 license, sir? I'll just make a note of it.
Yeah. First is the lift license. If you are a high-rise tower, lift is there. Lift license. Fire, if you are a high-rise building, fire CC clearance certificate is issued during OC. Every second year you have to renew. Lift first time is for 10 years. After 10 years, it is for 5 years.
Okay.
So 2 licenses. Third is all your electrical installations are approved, then only BESCOM powers. So ask the builder to hand over all the CAIG approved, stamped approved drawings with covering letter. So CAIG today comes for inspection randomly. They have been authorized or mandated to do inspections at least once in 5 years. So what is happening today is they come, give a notice and give a demand note, then they do the inspection. So third I have covered. Fourth is the KSPCB. If you have a STP inspection, depending upon the capacity, is 5-year license or 10-year license or 3-year license. 10-year for 100 KLD and below, 100 to 300 KLD is 5 years, and below above 300 KLD it is 3 years. That's what I think so. So that these three. Then if you have borewell, again borewell, every 2 years renewal is required. Borewell license also. License to dig, license to draw. So there are some things for borewell.
Who is the agency for borewell district?
Karnataka Groundwater Authority. Online it is.
Water Authority. Okay.
So previously inside BWC area, BWCSY was issuing it. Still they may be doing it, but the whole authority comes under Karnataka Groundwater Authority, which is affiliated to the Central Groundwater Authority.
Okay. Thank you,
These
sir.
5 licenses, everyone should have it. Otherwise, there could be penalty retrospective also.
Okay. Fine, sir.
So can I ask now?
Yeah. Nishita,
My name is
please.
Nishita. Yeah.
Yeah.
Sir, good morning first of all. And I would like to know what are the actual these NOCs what we mentioned now for a apartment which is less than 50 flats and which is around four floors. So what all would be applicable? One is a lift.
For 4 floors, it is less than 15 meters previously. Now it is 25 meters. Fire license is not required. If lift is there, yes, lift license is required. STP is there. You have an STP?
No, we don't have an STP.
How many flats?
It's 40 flats.
40 flat doesn't require STP, so you don't require that. So fire is not there, STP is not there. You have a borewell, then you should have a borewell license.
Yeah, this borewell one is a new thing. I don't think anybody knew about it. Okay, so we have to obtain that, right?
It's not a new thing. It is there for last 10 years. We are not educated, nor rather as residents, we are least bothered about this. These things come with a retrospective now. Then fourth is your CAIG or electrical drawings. To ask the builder to hand over the electrical drawings, approved electrical drawings.
So the builder, this is actually a more than 15-year-old flat. So the builder doesn't have, actually basically, I don't know that time who has done this Hoto, so they have not handed over. We don't have a single set of drawings with us.
Then you'll have to can't address this right now because those are 15 years old. There could be drawings available in CAG themselves. Copy has to be got from them, approved drawings. Because what happens now during inspection stage, 15 years no inspection has happened. That means
no. Now we have got recently we had got a notice from CA, that is Electrical Inspectorate. Right. So most of the compliances we have already done, including the transformer.
Yeah, they have not asked for the drawings.
So when they come, when they go, I don't know. They just put something and they go off, and might be I don't know, because they have never met anyone from the office bearers also. They don't come and they don't interact.
No. They would have given you a notice, demand note also give money. Unless some fees is paid, they don't do the inspection.
So actually we had got it last year in 23. So we paid the fees, yet nobody came. We had paid the fees online, nobody came. And again, then anyway, we have complied most of your requirements. So it's not that we haven't complained.
No. The minute payment is made, they come and inspect and give a report. Maybe your manager, who is someone has to get involved into it from your sides. They are not going to. So see, the main issue is MC member have to interact with government agencies. We don't want to interact. That means that doesn't help. Unless we personally go and interact, nothing moves. See, the minute we go, yes, we depend on some third party to do all our work, and then we say there is corruption. That is a very wrong process. If MC members can go and meet each year, AE to AE level, to the chief engineer, everything moves.
That means we can personally go and meet them, like to the offices also?
See, everything. I personally have gone to the fire officer, environmental officer for every of my license.
Okay.
See, what is happening is we think corruption is there. Corruption is there because agents are there is 100% corruption is going to be there.
No, we were told saying that if you go also, nobody is there to listen to you. You have to get it done, all those things.
See, ma'am, that is where the question is. We are hearing, we need to go. From Bangalore Apartment Federation, which has 1,200 apartments, we insist people, office bearers to go and meet. So one-to-one face meetings will solve 90% of all the issues. Anyway, that is a subject which every association has to look at it.
Okay, fine. Thanks.
Any other questions? Anyone?
Yeah, there's Ravi Kumar here, so I will raise my hand.
Please.
Sir, I'm from, we are from Fortuna Krish apartment.
Okay, where is it?
In Kalkere, near Hormao.
Hormao, yeah.
Okay, so just wanted to check with you. Just now you mentioned about the Karnataka groundwater recharge, where when hello,
Karnataka Groundwater Authority.
yeah, Karnataka Groundwater Authority. So with them, if our bore wells are dried and we are not yielding any, we are not, it's not usable at all. Okay,
Yeah.
we have a groundwater recharge also. We have all the ground. We are having groundwater recharge because we want to ensure that the groundwater recharge helps our borewell to recharge. But unfortunately, having that also, we went ahead and checked with Geological Survey of India. When we called them, they came and checked, and they said that the seismic kind of a thing is not accepting water in the ground levels, even though the recharge is there, recharge table is there. The recharged water is getting somewhere drained out to some other places, but you will not get the yield. Okay, that's the reason your borewell is dried up and you can't do anything much. Now, in this particular case, what I'm supposed to do?
Yeah, you are supposed to give a letter to KGB and seal the borewell. Actually, sealing means put concrete and seal it, so that otherwise, when you get Kaveri water BWSB, they will charge you 100 rupees per flat for using borewell.
Okay.
So borewell is connected with BWCP water. The billing will happen. If you see, if some of you would have seen in your billing, there is a borewell charges, 100 rupees per flat. So to remove that, you have to show that all your borewells are sealed.
Okay.
So there is a sealing process, and then get a certification that borewell is sealed.
Okay.
Many of the apartments have done it.
Okay.
You will have to approach. You will have to go and meet them and explain them. See, because what happens now, everything is unique. Nowhere any process is written due to that. You will have to meet them and find out the things. But this is the information what I have. You can seal it. Provided you have to give a notice, get it sealed, and get a certification it is sealed.
Okay. So one more thing I have. Okay. So for this, which office I'm supposed to go for Karnataka Groundwater Authority, sir?
There's only one office in Bangalore. Let me check and give you the address later on.
Yeah. Okay.
It's in utility building, I believe. So I had visited once. I think near that.
Oh, MG Road, utility building.
MG Road, near that central post office. You can just Google it out. Karnataka Underground Water Department.
Not underground, Groundwater Authority.
Groundwater Authority.
KGWA.
KGWA. Sure.
Yeah.
KGWA. Sure.
Yeah, they are the authority. Yeah.
Sure. Okay. And this is not, they come under a BWSSB, yeah?
No. They are BWCSB was given authority by them for BWCSB jurisdiction to give permissions. Because they didn't have resources, to the whole Karnataka, they report to the Central Groundwater Authority. BWCSB has been given authority by Karnataka Groundwater Authority to issue borewell licenses in their area of jurisdiction.
Okay, I'm just writing it down. Okay, so my next question is now regarding this lifts. So what has happened is we have all Schindler lifts. Okay. And they're all, but the thing is, regarding the license of the lift, right? How to go ahead and obtain the license? We need to call the Schindler and tell them that we give us this a copy of license that you have, or we should go ahead and approach the builder to obtain the
let me tell you, the lift vendor will not get you the licenses.
What do you mean by that?
Lift vendor will not get the licenses. He will only give you technical support.
Okay.
So, how old is your building?
Building 7 years old.
7 years old. So,
builder
would have got the license. So, ask the builder to share the license, because that is where the handover processes are not completed previously. No one knew it. Builder simply says some drawings and he walks off.
Yeah.
So today, ask the builder from his records to give the license. Otherwise, ask Schindler whether they have a copy of the license.
Exactly. Okay.
See, they may have a copy. when the project is completed, handed over to the this thing, because technically they only support the copy. The license comes in the name of the builder, not in the name of the lift operator or the lift manufacturer.
Yeah.
So
Okay.
you will have to, your license would be valid for first 10 years, subject to when it was got. Previously it was 5 years. It has been made now 10 years, about 5 years back, I think. So that you need to look at it. So
I
if
think
it is
we
not
got
there,
that lift in 2018.
so if it is not there, you'll have to apply and get it. Always, even if it is lapsed, please go and get it applied and get it.
Apply for license. And whom should we apply for the license, sir?
CIG, Central CIG, that is KEIG, Karnataka Electrical Inspectorate for the government.
Karnataka
Electrical Inspectorate for Government.
Inspectorate.
KEIG.
Inspectorate.
I'll share my numbers. You can connect me later on. I'll let you know. Yeah.
Gautam, so just give me a number quickly. No?
I'll put it in the chat. I'll put it in the chat.
Yeah.
One last question, Ramesh Rao, sir. Please. Any last questions?
Yeah, Ramesh has raised his hand. Yeah, please go ahead.
No, sir. My question is complete.
Okay.
Nothing.
Okay, fine.
Sir, one last question, if you don't mind, please.
Yeah.
Okay. This is a bit a legal kind of a thing. Yeah, sir. So many of the residents, maybe they are tenants. They are not. If they are not paying the maintenance for a long time.
Okay, what we will do is Abhilash will address this.
Yes.
Is this the right forum to ask this question, sir?
Yes.
This is what.
Now the legal part is starting. Now I'll take over. I'll answer all your questions.
I'll hand over to Abhilash. He will take over the important subject of how associations will address all issues, concerns, day-to-day running issues, and other things, and the association formation also.
Okay. Can I ask this
Thanks,
question
Mr.
now?
Mr. Gautam, thank you so much. It was very informative.
Thank you.
Fantastic.
Anytime you can get in touch with me. I'll share my phone number for anything to everything. I am available 10 a.m. to 10 p.m.
Yeah. Sir, you can stop sharing your screen. I will start sharing my screen. Yeah. Right.
My screen is not shared. You can go ahead.
Yeah, 1 minute.
Abhilash, sir, can I park my question now, or because I think you?
Yeah, I'm in my slides. Your question is covered.
Okay, sir. Fine. I'll wait. I'll go on.
How to type a message? Where exactly?
Sir, you will just see a square box.
Chat box. Chat box.
I'm not getting that. Anyway, okay, go ahead. I'll try that. Please go ahead.
Bottom line chat box.
Is my screen visible for everyone?
I can see it.
Not yet.
Is my slides visible? KSRA 1960.
I can see Abhilash. Others are also
Yeah,
able to see.
it's visible. It's visible, Abhilash.
Okay.
Yeah, now it is visible, sir.
So, good morning, everyone. I'm Abhilash Naik. I'm advising totally 41 plus RWA on retainer basis as of today. Almost some 30,000 plus flats under 41 RWA I'm advising on a day-to-day basis. Today I will try to reveal some of the mistakes made by our government while drafting the laws on association purview as such. So first, let's start. So there are 3 types of acts under which an association can be formed. So the first act is Karnataka Societies Registration Act 1960. Second one being Karnataka Cooperative Societies Act 1959. Third one being Karnataka Apartment Ownership Act 1972. Now let's understand when we have to look in a historical perspective how this association started forming. So our apartment culture in Bangalore started 2000 onwards, if we can trace back. During that time, the initial requirement was to open a bank account and to collect common area maintenance funds. For this, initially all apartment associations used to register under Karnataka Societies Registration Act 1960. So all was good till 2019, where High Court saw that this registration is not proper. Why? Because The section 3 defines for what all purposes you can register an association. Under section 3, so there are several purposes like sports act, sports purpose, literary, library, etc., etc. But common area maintenance as a purpose is not available under section 3 of KSRA 1960 Act. High Court made this observation and cancelled the registration certificate of first apartment, that is VDB Celadon in Yelahanka. Thereafter, based on this order was challenged in High Court again in a writ appeal. A writ appeal was also upheld, and based on this writ appeal decision, more than 150, 200 plus association registration certificates have got cancelled as of today by High Court orders. So in all such orders, High Court has advised them to form association as per provisions of Karnataka Apartment Ownership Act 1972. Later, the Registrar of Cooperative Societies found a new avenue to register associations. So they had powers. They referred Karnataka Ownership Flats Act 1972. This is different, KOFA 1972. Under this, one clause was there: promoter can take steps to form cooperative society or a company. The first notification came in the year 2020, where the Registrar of Cooperative Societies started asking associations to register under 1959 as a cooperative society. So the practice of registering cooperative societies, we can trace it back from the year 2020 onwards, from after COVID period. More than 50 plus cooperative societies got registered so far. So the story again goes back in the lines of 1960. All was good till 2023. The first decision came in one of the writ petition, wherein the court observed that you can form a cooperative society only if your plan sanction is both residential cum commercial. So only in such scenario you can form a cooperative society. And if your sale deed has a condition that you should form 1972, based on these two conditions, the High Court quashed the registration certificate of DS Max apartment. After this, in this judgment also, the court again asked to form an association as per provisions of Karnataka Apartment Ownership Act 1972. So there are some conflicting judgments. The single judge bench have given judgments to form cooperative society instead of 1972 Act in some decisions, but we should always, if any resident tomorrow challenges based on the writ appeal, so writ appeal always superimposes on the writ petition. So appeal will have a higher weightage compared to the writ petition judgments. If some residents wants to challenge this decisions, he can always go back and reverse the decision and always have a 1972 associations form. So we need to understand now the two acts are banned by High Court orders: KSRA 1960, Karnataka Cooperative Societies Act 1959. So the two avenues where you can get these registration certificates banned is one is you can file a complaint before Registrar of Cooperative Societies. Second is you can file a writ petition before High Court, get registration certificates banned. Why I am saying this? Because tomorrow any resident may quote this High Court judgment and stop paying maintenance. We are illegal association, we are illegal cooperative society. As per High Court judgments, we are not supposed to run these associations. So it is left to, if all residents are quiet, nobody is challenging, you can run successfully. If somebody is challenging and somebody is filing complaints before ROCS, again it's a problem. Recently in one Prestige Augusta Golf Village, the Registrar of Cooperative Society passed the order not to collect maintenance because they were registered under 1916. High Court also, they have been given liberty to change the nature of association within 3 months and stop collecting maintenance within 3 months. Based on this ROCS, they challenged that order in High Court. This way, both 1960 and 1959 are a no-go acts, except because Karnataka Apartment Ownership Act cannot be made applicable on villa community. In such scenarios, a villa community can go for cooperative society. So only exceptions for cooperative society is villa communities. So some of my clients who are registered under cooperative society, now they are facing many issues. Why? Because many of your office bearers are mostly working employees who cannot give time every day, day in, day out, to manage the affairs of the association. And the time period is also too long. In all my clientele, many places I have seen all my office bearers get exhausted within 6 to 9 months. They want to take early retire, they want to file resignations and want to exit. There are many reasons for it. And term of 5 years, once you elect people, and they have to sit for 5 years continually, which is a long period, because under Cooperative Societies Act, they have to follow the Cooperative Societies Act, which prescribes the time period for 5 years. So I had a very long discussion with ROCS and all. They are not willing to reduce this 5 years. So I am also advising many of my clients to go for 1972, because this is too much government controlled act, wherein compliance is every year you have to appoint the auditor recommended by the registrar of cooperatives. You cannot have your own independent auditor. Every year you have to go for renewals, and if many people resign, you have to go for re-elections, and elections are also an expensive affair, which will cost you around 2 to 3 lakhs to conduct one simple election in a cooperative society. And I'm not recommending, because for these reasons, for a for any societies to form a cooperative society. So under 1972, the advantages are like it is much having self-governance. So you don't need to renew your associations every year, and you don't need to go for a auditor who's recommended by registrar of cooperative societies. You can always have bank statements, audit reports formulated by your chartered accountants, and produce it before all residents every year for their verification. So there are two ways bylaws can be drafted. Sometimes builder gives liberty for you to draft your own bylaws. So if such liberty is given, well and good. If such liberty is not provided, you may have to amend. Some places I have seen across, builder has imposed one-sided terms and conditions on residents that they should not collect maintenance till all flats are sold, and association should pay them royalty every month for rupees 1.5 lakhs or 2 lakhs for giving all the commercial shops in their handover. Such all those one-sided terms and conditions can always be restricted and stopped by the entire resident community. So there are best and bad model of bylaws. I have come across several types of bylaws. In one of the bad model bylaws I came across in Bhartiya city, there are like 18 towers in one apartment block, and the executive committee member, they are restricted to only 5, which will again the power will go in only one group of 5 people, which is not having equal representation of every tower. It may become a bad democratic practice of running an association if that kind of rules and regulations are there in a bylaw. And what is the best practices of bylaw, in my opinion, where I handle many of my clients are all like 500 plus, 1000 plus, 2000 plus, 3000 plus flats are there in most of my clienteles. So in such scenario, the best practice is every tower should have a representation of 1 or 2 members, and the executive committee, management committee should get elected internally by all the representatives of all the towers. So this way, the executive committee knows that who is going to work because they will know that who is going to work for the welfare of association. If office bearers, president, secretary, treasurer, they are elected directly by residents, there may be an internal conflict between executive committee and office bearers, which may not work in best interest of all residents. So the best practice of bylaws should be elect tower representatives, give them the freedom to elect their own office bearers, because they know the best person who will give their time and energy for the association. That way an association can run successfully. So also ensure code of conduct. Why this code of conduct? Because I have seen many people mass resignations happening due to one or two persons in the executive committee who go and reveal unresolved disputes before residents and make you enemy with all residents. So this situations should not happen. So you ensure that you make them sign a code of conduct document, which should contain clauses like non-disclosure of unresolved issues. Only approved matters should be discussed with residents. And also, if they are absent for 3 or 4 continuous meetings, they should the executive committee shall have the power to remove them from their position. All such rules you bring in so that you maintain peace and tranquility with all the office, and your functioning should go without any disturbance. So this way you hold every executive committee member or office bearer accountable for the job they are taking. So ensure that you get a code of conduct signed between them. Now, what is the solution for associations registered under KSRA 1960 and 1959 apartments? For apartments, they can pass a resolution. Already registered apartments, they can pass a resolution in their general body meeting to migrate to 1972. So there are 2 challenges here. One is, if builder is willing to register, yes, you can go ahead. If builder is not willing to register deed of declaration, then what? So in such a scenario, you pass a resolution with this thing, with the resident community, whatever your existing 1960 association, in that name only you go and register DOD and insert the documents like legal notice sent to builder and general body meeting resolutions in the deed of declaration, and go and register the deed of declaration in the name of welfare association only, and run your association as a 1972 association, and the grantor being the president, and you give authorization to president or secretary, somebody who can register this document. This way you can make a legally valid document, and if tomorrow if any resident challenges this deed of declaration document registration, then also you will have the proof that general body, you were authorized by general body meeting to register this deed of document. So this way you legally prevent and also you document the legal notice and the unwillingness of the builder to register deed of declaration. So all these documents, if you insert it in deed of declaration, this should safeguard you from any legal issues faced in future. This way you can make sure that you're a legally valid association. So now coming to what is the procedure to register 1972 association. So what, let me go through the clauses available in Karnataka Apartment Ownership Act 1972. Section 11 clause 2 states that deed of declaration and bylaw shall be filed before competent authority. So earlier the practice was the builder used to frame a document, deed of declaration, and insert the bylaws in the same document, and used to register this entire document before sub-registrar, who is a revenue authority where you register your properties. So before that authority, we used to register. And who is the competent authority for 1972 Act is, that is Registrar of Cooperative Societies, Malleshwaram, if you are under Bangalore jurisdiction. If you are outside Bangalore jurisdiction, it will be the ROCS of that particular district. So you register deed of declaration. Nowadays, sub-registrars are not allowing the bylaws to be inserted. So you only register DOD, attach, you formulate one easy to follow bylaws for that document. you send a copy of this document before registrar of cooperative society by post, because physical filing they're not accepting, they're not acknowledging our physical filing due to many issues. Because what has happened is the act has defined competent authority as registrar of cooperative societies, but our state government, when they formulated this act, as an addendum to this act, they did not frame rules, regulation, jurisdiction, duties to the registrar of cooperatives. Because of lack of powers to registrar of cooperative societies, registrar of cooperative societies is not entertaining any disputes of 1972 association. In that matter, you have to go for civil court in any dispute arises. Dispute may arise like election dispute may arise, misappropriation of funds may arise, for which you can file a criminal case, and any bylaw violation kinds of cases may arise, which you can again go for civil court. So civil court will be the appropriate authority to decide on the disputes of 1972 association. So what all things a deed of declaration should contain? First thing is description of land, UDS, super built up area, flat numbers, parking numbers, visitor car parking space, all the amenities, all the sports amenities, along with that all the schedule of the entire property. So this way you can insert all these documents and get a deed of declaration registered either through a builder, or if builder is unwilling, there are other steps which you can take as discussed earlier. So now many bigger apartments, now they have commercial shops, there are commercial meters installed inside there, but there is one clause in conditions, there is one act in the BESCOM department, conditions of supply of electricity of distribution licenses in the state of Karnataka, clause 3.1.1. As per 3.1.1, if commercial usage is less than 25%, these meters have to be considered as residential meters. If you have installed commercial meters as of now, there is a provision you can get it registered as residential meter based on this clause. If they are unwilling, you can always approach electricity ombudsman, and also you can go to High Court and get a stay against conversion of residential meters. Most of the apartments, no apartments cross more than 25% usage for opening any shops, because many apartment complexes will have shops like pharmacy, grocery store, a saloon, and many other items. As much commercial space they have, they can open that many shops. So in such case, if it does not cross about 25%, you have a provision. If they are demanding you to pay some penalties, I have come across one or the other two apartments where they have levied a penalty of more than 7 lakhs. And we went for ombudsman and we got the order reversed against them. And we are enjoying our facilities as by paying the residential rates. So commercial rates will be around 7 or 9 rupees. Instead of that, you can easily enjoy it as a residential meter by paying only 3 rupees or 4 rupees. So this way you can utilize this provision for your advantage. So recently the Pollution Control Board has passed a new notification that any DG sets which are having which are of the capacity of more than 240 kilowatts or plus, they should fit this retrograde emission control devices. So we are trying to file High Court writs to get a stay on this, because this is a new recent thing by the Pollution Control Board. So some of my clients, I have come across few instances where the GST department has levied a penalty of more than 2.8 crores. Why? Because they were paying GST for only above the money 7,499. So if there are two ways to prevent payment of GST. One is if so your chartered accountant should advise you if you are collecting GST, if you are collecting common area maintenance above 7,500 per month. One way is to ensure to pay GST so that you do not get any penalty. Second way is your chartered accountant should advise you to collect that excess money in a different heading to prevent paying GST. Some apartments are doing, if you are collecting in such a way and giving proper audits and accounts to GST, then you may not be supposed. So because GST department in 2 apartments, they have taken note of it, where CAM is they are collecting above 7,500. They have taken note of it, and they have for 3 years continuously they paid only for the amount paid above 7,500. Now they have done back billing of past 3 years. Along with that, they have levied a penalty of almost some 1 crore plus for total amounting to 3 crores in one of my clients' apartment. So this way ensure that your audit books are clean. So also I have seen whenever a general body meeting is conducted in any apartment, there are lots of fights happening, due to which office bearers are also not showing too much of interest, mass resignations happening some places, and all these problems can be resolved. How you can do? There is uncontrolled freedom of speech. Sometimes I have seen come across many fights happening, physical fights happening, and in some of the associations they invite police to control the crowd, they invite bouncers to control the crowd. You would have decided to conduct a GBM within 1 to 2 hours, which may extend to 4 to 5 hours, and unnecessary wastage of time, unwanted questions are asked. What is the solution for all this? Recently in 4-5 apartments, I gave them the solution to conduct online general body meeting, which they conducted it successfully, wherein they brought in, wherein they suppose just for in a Zoom call meet, where you can restrict the freedom of speech by allowing to mute the participant who raises their hand. So this way, first half an hour you can give your presentation, next half an hour you can go for Q&A. Each person will be given only 2 minutes to he will be given only 2 minutes to ask his questions, and you will answer it within 1 or 2 minutes. So this way you don't give additional time for everybody. And later you go for polling or voting, online voting, where you open the poll within 1 minute. You open a poll and easily get all the votes. Within 1.5 hours to 2 hours, you can completely finish the GBM. So this is the best method of conducting GBM. Even though your bylaw does not have a provision to conduct online GBM, still you can pass a resolution in general body meeting that for in future all such general body meetings may be conducted online for larger participation of audience. This way you can pass it and conduct your online GBMs. This way you can ensure to have a conflict free general body meeting without any cross stoppage of cross questions being done when you're doing presentations in online physical GBM. All things can be prevented, so that a resident becomes responsible to use his time only when he has provided that time. So after presentation, he has to make notes and ask the questions at one point of time, not at every point of time. So this way you can ensure that you can conduct successful general body meetings. So recently everybody may have known about the accident which happened in Prestige Lakeside Habitat, which caused death of one child due to electrocution in swimming pool. So what you can do, all the office bearers, many of my clients, what should we do to indemnify ourselves in such case of loss of life or any accident, loss of limb to any person? What should we do? Many clients may ask. See, there are 2 ways to approach this. One is insert an indemnity clause in bylaws that office bearers cannot be held accountable for any accidental loss of life, limb during for usage of any sports equipment, swimming pool, etc., etc., by the residents. You put one clause there. And also in the vendor contract, where you enter contract with vendors who do housekeeping maintenance of swimming pool and sports equipments, there also insert one clause. You need to insert one clause stating indemnity in case of any faulty maintenance of such swimming pools or some electrical equipments. The office bearers are indemnified against any loss of life. This way you can hold yourself indemnified in case of any such event happening. This way you can ensure that even if some police arrest comes forward tomorrow, they want to hold a president or secretary accountable and wants to make arrest, you still have a document to prove my role is not there, I'm only office bearer. These are the technical persons who maintain, and for their faulty maintenance I cannot be held accountable. At least document yourself so that any accountability does not arise on you. This way you can prevent. So also there are many agreements you need to enter: rental agreements for commercial, vendor agreements for housekeeping staff. In rental agreement also ensure that they don't ask you to enter with a lock-in period, because if there are unfavorable conditions you need to check. And also termination clauses should be very strong. Ensure that if they do not pay, if they have paid a certain deposit money, if they do not pay rent for, suppose for example they have paid 6 months of deposit money and they do not pay rent for continuous 2 months, you should be in a position, there should be a clause available in the rental agreement that in case of non-payment of rent for 2 months, you can terminate within 1 week notice. Such strong clauses if you have, you can ensure that you can enjoy your commercials without any discrepancy or stoppage of payment by these commercial vendors. So such clauses are required. And also service vendor, also sometimes if they are not providing services, then you have to ensure that they pay some penalty for not providing services. So maybe watchman staff, housekeeping staff, or the STP maintenance staff. All these things you need to. And also one clause, they have to maintain as per the government required standards. If they're maintaining the DG sets or STP, WTP, whatever government standards are required, based on those standards, they have to maintain this equipment so that there is no tomorrow you do not face any penalties or any other things in case of they come for any surprise check or anything like that. So also there are many police station incidences wherein office bearers have a lot of fights with sometimes with residents for just levying a penalty, for increasing camp prices. So in such situations, be ensured that you are backed up by general body meeting resolutions. Why? Because when a resident goes and files a complaint before police station, you can always say that I was backed up by large majority residents and there is general body meeting resolution as a proof. So this is the proof. So if you have to hold accountable, you have to hold accountable all the residents of this flat. So such way you can hold them accountable. And also define list of penalties: illegal parking, pet pooping, misbehavior at security, wrong, throwing garbage at unwanted places, and usage of any causing damage to any property. All those things you can pass a general body meeting resolution, make a list of penalties. All those things you can get it passed in general body meeting. And tomorrow you want to hold such resident accountable, hold him accountable on the general body meeting decision. So that way you prevent yourself from unwanted harassment in police station. And also the two main court issues we file is I file in regularly in many associations is defamation. So certain group of residents start defaming the office bearers or the executive committee, and these residents are IT people, or they have almost 10 to 7 working job and they don't want to give their time for all this addressing all these people. sometimes mass resignations happen and there is collapse of the association and they go for re-elections again and again and again. So this should not happen. In such situation, the associate office bearers have to take legal action against such defamers. So two option is available: file a private complaint before a magistrate court for punishment. Second one is you can file a civil suit for damages, for compensation for character assassination. All such things can be done so that you keep them busy in the court work and they don't unnecessarily make comments or pass character assassination comments against all the office bearers. This way you can hold them accountable. Scam recovery is also one more aspect where people don't pay maintenance regularly. I have come across, I recently filed some 25 cases in one of the largest apartment here for CAM recovery, almost recovering 1 crore plus common area maintenance out of this 25 association members who are not paid CAM for almost 6-7 years. So we file money recovery suits and also have made insured in these clientels have made an application based on this Telangana High Court judgment to disconnect water, which is a paid commodity, which is supplied through tankers in these apartments. So this way I'm experimenting to get an order to disconnect water. In Karnataka, and there are several High Court judgments which say that water and electricity should not be disconnected, but I'm going here in a different line stating that water is a paid commodity supplied through tankers where every resident has to contribute. This way I'm asking the court to give an order to disconnect water in behalf of the association. So that way I'm trying to hold them accountable. And 3 things you can always do is you can disconnect DG. You can stop giving them clubhouse amenities, all such, and also if garbage pickup you want to stop from the door-to-door garbage, you can stop that, but he should not litter or loiter around in his own place, which may become problem for all residents. You can take a call if that is the case, and also visitor access through Adda app or anything, so that you pinch him a bit so that he pays the common area maintenance regularly. And also penalties if there is a delay, if he's not paying on month on month regularly. What are the penalties you want to install? You pass it through a general body meeting resolution. This way, hold him accountable, and if he still does not come forward to pay, you have an option to file a money recovery suit before civil court and hold him accountable, and also attach his property for the recovery of common area maintenance. And also some people unwantedly they file cases and still they want to contest for elections. So there also you can prevent them from contesting elections by stating a simple thing, that conflict of resolution. Because if he has filed a case against association, tomorrow if he wins and comes back, he will be contesting the case against himself. So for this reason, conflict of interest clause we can exercise and disapprove his nominations for contesting elections or involving himself in any administrative affairs of the association. So sometimes builder made bylaws can be defective, term which we have already discussed. Pet issues, there are we need to understand there are community dogs versus stray dogs. The law says that pets should be given a pet play area. Some area should be demarked for them to defecate in such places or play in such places. So all the new apartments which have come after 2016-17 onwards, they have been made mandatory that they need to show some areas pet play zone. But apartments which came before that, they would their plan sanction wouldn't allow. So they may not have shown for them, it may not be applicable. But for associations which are formed after 2016 onwards, it's a mandatory thing for pets. Now coming to stray dogs, many residents illegally they bring stray dogs inside how to prevent such instances. So we need to fall upon this definition called community dogs. So in one of the acts, community dogs means such dogs which are born in that area. So first you need to make a declaration that bifurcate the dogs which are born in that area. Only those dogs will be allowed inside to be residing as community dogs. But outside dogs will never be allowed. Stray dogs can never be allowed. So this way you identify community dogs versus stray dogs. So slowly you can prevent the stray dogs from entering inside and ensure that you ensure that residents are not disturbed by any new stray dogs coming in. So there are many commercial businesses run at apartment premises, tuitions, cloud kitchen. Again, you can pass general body meeting resolutions. You can levy penalties against them, and also file complaint before BBMP for usage of residential premises for commercial purpose, and take action against such residents. So underground borewell water department, they have issued notification. If you are drawing water up above 10,000 liter capacity per day, there is some recharge money you need to pay. Recent notification, but it has not been implemented strictly anywhere. Only when they come forward to uh, only when they come forward to levy penalties in a stricter way, then we may come across. BESCOM penalties on commercial shops. If BESCOM is demanding any penalty to be levied, as already discussed, you can approach an ombudsman based on the above clause, file a complaint to reverse that notice to pay penalty, and get a appropriate order to run it in a residential meter only. Some apartment are facing substation builder has not installed substation, and BESCOM wants to levy heavy penalties on the association. So there you can approach High Court and get a stay against BESCOM, and make the builder as a party and try to hold the builder accountable for all that substation issues. Pollution Control Board is also demanding many apartments to do the fitment on DG sets of retrograde emission control devices, which is again a costly affair. If your DG set is about 240 kilowatt. So many people have a confusion that why is land not transferred in the name of association till date. My opinion is in entire Karnataka, not a single apartment has got the land registered or transferred in the association name or cooperative society or welfare association. Why? Because our state government follows registration procedure where the land is sold proportionately to all flat buyers. So there is no question of conveyance date. So if conveyance date in lines of Maharashtra, if it has to happen in Karnataka, then our state government has to amend the registration procedure and bring in the new law. So this may become a possibility only if state government brings a new scheme. So I'm done with my slides. I'm open for any questions.
Yeah, Abhilash, thanks.
Yeah.
It was a very comprehensive kind of a presentation that you have given and very well articulated. Thanks a lot for that.
Yes.
I have a question. My name is Ravi Kumar. I'm from Fortuna Krish Apartment, Kalkere, Hormao. I'm the president of the association. See,
Yes.
just now I heard about you have filed a case to ensure that people who are not paying maintenance and water is considered as paid resource, right? So for that, government, what is the take in that one? Is government is really inclined to this kind of a hearing, or they have a difference of opinion? Number one. Second, I'm not asking for a judgment kind of a thing. I'm just trying to understand the pulse of it. Okay, that's what I'm trying to bring it, because I have a lot of cases, so I'm very much interested to know about that. One. Second thing is, our apartment is something which was got commenced in 2014, and we don't have a pet area and all, and there is challenges with people going ahead also for a garbage area. So there is a dispute going on still with the landowner, wherein landowner claims that this land is mine. I have given it for the builder to build, but we have all paid equally for it. But is this comment going to continue, or we can arrest this kind of a comments and we can put a harassment kind of a thing against the landowner who is doing it? Please throw some light on it.
See, first thing, government has no take on common area maintenance as such. So it is, see, you association should take responsibility to collect maintenance from all residents.
Correct. Yeah.
So that's one part. So government has nothing to do on it. So second is your builder and see, whatever claim your landowner is making and builder has not he has given some certain part of land to builder to construct, but he has not constructed. But that has to be looked into documents, like what are the plan sanctions approved and whether was any plan sanction approved to construct any apartment there and builder has not constructed. So that has that cannot be addressed without looking into documents.
Abhilash, I have an answer to his first question. See, first question is if your association, see, legal means has to be covered to take recover the money, maintenance or anything. See, first is your bylaw should be very clear. In our own case, we are issuing legal notice now. We are going to the court for one person who has not paid 4 lakhs. So it's a legal issue which I think Abhilash will explain in a better way that how it should be done.
Yes, Gautam sir, because we have registered in 19 Karnataka Apartment Owners Association, 1972 Act only we have registered.
No issues. What I'm going to say is in your bylaws there should be a process. If he doesn't pay within, you give a written communication. Then through your legal lawyer you give a notice. Then you go to the court.
Okay, sir. Yeah. I understood that. Yeah.
Yes. So generally, there are two things. If bylaw does not define the measures to be taken against, you conduct a general body meeting, get an approval for measures to be taken against such resident defaulting on paying maintenance. That way, you hold him accountable.
Exactly.
Okay.
One line I want to add: management committee members are implementers. Any management is an implementer. It is not a policy decision taker. Any decision has to be first approved in the AGM, then only it can be implemented. So please understand, we are all implementers, not policy decision takers.
Yes, sir. Yeah, got it, sir. Yeah.
Okay, I will.
I have a question.
Yes.
Okay, so can the management committee impose a fine or interest? Just like, for an example, I have came across an apartment where the maintenance is around 3,000 and they are implementing the interest of 6,500, means almost double. So are they authorized to do that? The
See,
only
if
reason the people we can
if
default
approved by general body meeting, if bylaw says, if bylaw does not say, then if it is approved by general body meeting, yes, they can. But if only office bearers try to levy a penalty against you, that cannot be accepted.
Okay.
So in our bylaws, we have written 24% interest. So automatically, if payment is not done on time, 24% automatically gets calculated. As on date, we have no issues. 6th year, everyone who is defaulted is paying those interest.
So in some other bylaws, they have written because the invoice is raised every quarter wise, 4 months once one invoice is raised. If they do not pay that advance scam, they give a buffer time of 10 days. From the 11th day per day, 59 rupees is added. If some apartments do not want to go percentage wise, some apartments are going on per day 100 rupees, or some apartments are charging per day 50 rupees plus GST, 59 rupees they are collecting as a penalty for delay. My suggestion would be best would be to go per day charge, don't go percentage wise, because it would be very minute amount.
No, calculation becomes very difficult because our system, in the system, it gets manually. If you do it, it becomes very difficult. Second thing is penalties for anything you want to put, it is allowed, but subject to AGM passing it. So get it all your penalties for dog poop or not cleaning or throwing in the corridors, anything. So that needs to be first passed in the AGM, then give 1 month's time to implement it.
Okay.
Thank
Yes,
you.
I will take. Yeah, I will take Rishi sir's question. Yes.
Hey, thanks, Abhilash. Really nice session, lot of information shared. I had a bunch of questions which I had typed, right? So I think there was some discussion around the association and the vendors being indemnified. Just want to understand, why do we want the vendors also to be indemnified against, let's say, a faulty maintenance?
See, your questions, should the clubhouse be under commercial meter? Clubhouse can be under residential meter, provided if your usage of that falls within 25%. Because in there is an ombudsman order available. Everyone, you can, if a commercial meter is installed, you can file a complaint before ombudsman and get the meter changed to residential.
Can I
Possibility.
can I clarify? See, look at the
Yes.
electricity bill of that particular connection. Look at the sanction load on that, and see the connected load to the clubhouse. Your common area may be one common meter. Clubhouse, only the load on clubhouse you see. If it is well within that 25%, you have to prove with all the documents and go and put a application and then go to the ombudsman.
Okay. And 25% of the entire residential load, which means also include the residents, or only the
No. I am very
only
clear
Entire
the
on
complex.
that particular meter bill.
okay. Okay.
So look at the, no doubt you can calculate overall, but it will be better to do it on your that particular meter.
Got that. Got it.
So your third question is, there are no rulings that whether CAM should be collected per square feet or per unit wise, because all these things are decided in general body meeting. I have come across where 3 BHK are more in number, 2 BHK in less in number. There in general body meeting, they have decided to collect unit wise. Where 2 BHK are more in number, 3 BHK are less in number, I have come across there they have decided in general body meeting to collect per square feet wise. Both are correct, because you are backed by general body meeting resolutions. Both are correct. So people will always, you purchase a flat, whatever you are, you also have the knowledge that 3 BHK are less in number, 2 BHK are more in number, so they will always vote for per square feet. If 3 BHK are more in number, they will always vote for per unit wise spring, because that will favor them. So generally you have to go with general body meeting decision only.
Okay. Okay. Thanks.
Okay.
And then I had two more questions which I mentioned in the starting, right? The indemnification thing.
See, vendor, no, I'm saying I discussed that office bearer should be indemnified, not vendor.
Okay. Okay. Got that.
Office bearer, tomorrow they'll do faulty maintenance, which may cause death or loss of limb of any person. Then you office bearer should not do the rounds to police station or unnecessarily face trouble. For that reason, I advise to insert indemnity clauses.
Another thing, what we have done is we have taken third-party insurance for accidents, not the maintenance part of it. Third party, if someone, say, let us say common area comes under the ownership of the association, RWA or AOA. Someone keeps a pot on their balcony, or something falls from someone's balcony on a person who is walking. And when we say third party, they are not residents of the apartment. They may be visitors or a supplier, anyone. On some accident happens, the insurance is covered by us in that.
So next question.
I'm Ramesh.
Yes, sir.
Can I talk now?
Yes, sir, please.
Sir, what is grantor and grantee in registration DOD?
So in DOD, we only use the word grantor. We don't use the word grantee. So whenever the signing of the DOD has to be done by grantor. Generally, what happens is grantors are all owners only, but we authorize the builder to register on our behalf.
But who will be the? There's only one grantor, and he takes over the property. But who is going to give it?
So generally what happens, builder would have inserted a clause in your sale deed if you buy properties, because this practice is not uniform across all the apartments.
Okay.
In your sale deed and sale agreements, generally builder would insert a clause that you have authorized him to form association as per provisions of 1972.
Okay.
If that clause is there, then he will become the grantor. If that clause is not there, but still he goes and registers DOD, and he will say that my duty to form association is done. You take this document, you run your own show. I'm not responsible from tomorrow. So you cannot hold the builder accountable to give to provide maintenance till he gets. Sometimes builder will delay in getting OC and all. You tell him that there are rare judgments. You provide maintenance. You cannot hold him account. If he wants to exit, he will exit. You cannot force him to provide maintenance.
Can I come in? Can I come in for this?
My
All
second
the
question, sir.
no, on the grantor, let me. All the partners who are involved in development of the project are grantors. Landowner, GPA holder, developer. They are the grantors.
Okay. All right, sir. And then my second question is, we have registered our DOD and bylaws in the sub-registrar office. Is it valid or invalid, sir?
That's valid, sir, because that is the provision as available as per the Karnataka Apartment Ownership Act 1972. Not a single association has got registration certificate under 1972 till date, because the procedure under the Act itself does not state any procedure to obtain a registration certificate. So there is no question of receiving a registration certificate under the Act 1972 Act. So
But
this is your legal identity. With this identity, you can approach any court, any tribunal, any authority to file a case against builder or any other resident or any other things you want to show yourself as an identity. This is your document.
Okay. No, you are telling about this cooperative register of cooperative societies in Malleshwaram. But we have registered in sub-registrar office of Revenue Department in.
I said about filing these documents before him.
Okay.
So I did not speak about registering these documents. I said about filing. So how you do filing is you send it by post. You keep the postal acknowledgement, because there is no procedure prescribed under the Act to do filing of these documents.
Okay, understood, sir.
If you go physically file them, now they are not accepting. You send it by post.
Sir, now the builder has transferred all the apartments to the individual owners, but the common area facilities are still in his name. So he is asking for the registered documents for transferring it to association. Is that right thing, sir? We have to get it registered in our.
That's why there is no provision to get the land registered in the association name.
Okay.
So there is no question of
common area facilities, maybe a clubhouse and other things.
See, the moment you start collecting maintenance to maintain the entire apartment, that means he has transferred all the common area. Tomorrow, anybody has to come inside your apartment. They have to ask your association permission and enter. You have the powers even to restrict the landowner and builder to enter inside. Their job is to construct, sell the flat, and go. That's all.
I have a small query in this, Abhilash. See, what happens is when the whole plot UDI is not shared among the owners, he is keeping some UDI. Then that UDI should not isn't it should be transferred to the association with a khata number?
Sir, now the problem is I will just refer. There is one judgment available in Tamil Nadu, wherein the UDI was distributed unequally amongst all residents, and builder tried to keep some UDS in his interest. He is shown in the plan sanction document that he is going to divide all the entire UDS of the entire land proportionately to all, but he distributed disproportionately. If this is the scenario, you have a right to file a case and get the excess UDS available in your name. If plan sanction document, you have to refer the plan sanction document which describes your land. This is one scenario. And builder, if in the plan sanction he has shown that he will have ownership over certain part of UDI, then you are helpless. You will have to go with that. So your source document will have to be plan sanction document.
Yeah.
Okay.
So basically, what you have to do is look at the complete plot, what is shown, what is the square foot, and add all your individual houses, total UDS given. If it is matching, that means it is distributed to all. If it is not matching, if it is less, then there is something which is still holding on to.
See the yes.
Can I ask Abhilash?
Please, madam.
Nishita.
Hello. Abhilash, just continuing on square feet and unit basis maintenance charges. As per KAOA 1972, clause number 10, it is as per UDI, no? So
So that can be interpreted two ways. Undivided interest.
Yeah.
Undivided interest can be per unit wise also it is undivided interest. How will you interpret the meaning?
No, undivided.
Because this was the same debate I had with one another apartment.
Okay.
I can interpret undivided interest in two meanings. Undivided interest will also be per unit wise. Undivided interest will also be per square feet wise. So which definition will you choose? So this definition has to be accepted, passed in general body meeting by majority owners.
Okay.
This is a confusion of the lawmakers which have put in the act.
Okay.
Okay.
It's another point. My point was you were referring GST collection. Okay. You told us there are certain ways how that 7,500 billing can be divided under different headings. What are the examples and how it will sustain?
So your chartered accountant should advise you on this topic. I'm not much educated on this topic because what all headings are available.
Okay.
Because he should advise you if he can collect the excess money. Even if you pay 1 rupee, you will have to pay 18% for entire 7,501 rupees.
Yeah, that is true. That is true.
So that way, your chartered accountant should give you some to collect it under some other building repair fund or some other which is not taxable money. So that way, you can give that benefit to the residents who are paying excess.
Okay.
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 Yes, Nishita, madam, you can ask.
Yeah, thanks, Abhilash. I had three questions. Our apartment, we stay in Hebbal, which is in East Spring season in Sanjay Nagar. Our apartment was constructed in 2008. So we have registered under the Societies Act, which is got registered in 2018. So now what is the confusion is we need to renew the registration certificate. That is the as per the Societies Act. So now the confusion is now what do we do? Because when we are going to register, they're asking us for the balance sheets from 2018, which we don't have because the earlier office bearers, we were not into the audit basically. So we have the audited statements from 21-22. That is from the time I had taken over. So my question is now what do we do? Now do we continue to renew under the act or should we transfer it to the KOA Act? Like what is it? Like actually we are confused.
Best option is to migrate to 1972 Act because you are under a ticking time bomb any day. Any resident who knows about this High Court judgment will always complain to you that you are an illegal association. I will not pay maintenance. From tomorrow, if he says that, he is right. He can always go and file a complaint before Registrar of Cooperative Societies. And Registrar of Cooperative Societies, nowadays, they are giving orders to associations registered under 1960 not to collect maintenance. So this way, you will be blocked from performing your day-to-day activities by ROCS. And also one more possibility, any resident can go file a writ petition in High Court, get your registration certificate quashed and also your accounts frozen. So ensure that you call a general body meeting and take a decision to migrate to 1972.
Okay, and any idea what would be the approximate expenses for that? Like
you please contact me, madam. I will tell after the meeting. I'll share
okay,
my
I'll do
number.
that. I'll do that. Yeah, I'll do that. And one more question I had is OC mandatory for these old buildings, which is 15 years old? Is it required to take or not required to take?
See,
because we don't have an occupation certificate.
Let me come to this. See, without an OC, that building is illegal. As simple as that. You cannot get an OC today. OC is given, then only occupation can happen.
But sir, that time I don't think in 2008-9, I don't think it was very mandatory to get these things like.
How many flats are there in your this thing building?
40.
40.
How many floors?
So,
3 floors, sir. 4 floors, 3 floors.
Those days, maybe it was not considered a high-rise area and all. So if it is not asked as on date, there should be no problem. Legality will come into picture only if there is deviation. So sanction plan was there. You'll have see today it cannot be addressed after 20 years, 15 years when the building was bought. Builder is there still.
Builder is there, but you know, right? Sometimes they don't bother to.
No, that's what I'm saying. So legally, it has to be looked in the town planning. What were the rules those days?
Yeah, those days I don't think there were rules.
Sir, I guess that these small apartments will not get OC because they are under the limit of normal construction.
That's what. If it is between certain area at certain floors, you don't require OC. You require only a sanction plan. See, plan has to be approved. Plan has to be approved, not OC.
Yeah, plan is approved. That's
then
not
that's enough, I think.
That's enough. Yeah.
And is there any cap on this transfer of ownership whenever a sale takes place? So they have to pay a certain amount to the association. So is there any maximum cap on it as per the law?
You cannot even take as such.
We can't take, is it?
So what are you doing? Yeah.
No, I believe she's talking about something membership fees or something for the
membership fees and transfer of.
No, there are
you decide in general body meeting what is the membership fees you want to collect for anybody who sells his flat.
Two things. One is membership. One is flat transfer fee. Maharashtra has certain clause which you can buy in under Cooperative Societies Act. Karnataka doesn't have that. People have gone to the. How much?
We haven't taken. See, this is what I mean to say is, now suppose if I sell the flat in East Spring and the new owner comes in, so does he have to pay any, like that is what is called as transfer of ownership? You're not taking any percentage or anything.
That is not transfer of ownership. Generally what happens, the practice followed in several other associations is on what all headings we collect, move in, move out charges we collect. One thing. So again, membership fees, whenever a person sells a flat to some other new person comes in, he has to become member of this association. You collect some fees from him to make him a member. So this way you pass a general body meeting resolution and hold all residents accountable to pay such move in, move out charges just to generate some extra funds for you to run the association.
Our bylaw says only 1,000, and I've come across some associations who are taking around 20-25, not for the membership of course, but as under the thing of transfer of ownership.
There will be, because you are a small apartment, because in some clients I have, yes, they charge like 20-25,000 because there will be clubhouse membership and other things and all. Maybe they may be charging a premium in some apartments. Yes.
But there is no law for that. So you'll have to be very clear on that. There is no written law regulations. So it can be illegal also.
No. But if backed by general body meeting or AGM resolutions, then they're legally.
I had.
Sir, our present.
No, let me one specific case. Someone went because they were charging 1 lakh rupees for transfer. Someone went to the court and court said, "What services are you giving for flat transfer?" So that was rejected. So Maharashtra had open-ended one. Then they fixed the charges in the by act itself. So otherwise, people are charging whatever they want.
See, now the problem is we cannot bring Maharashtra laws in Karnataka. Our courts will not accept Maharashtra. They will only say you go to Maharashtra and
exactly. I'm only referring. In Karnataka itself, someone was charging. Court said, "What are you giving services to give them? Because it's a flat. It is not a cooperative society or anywhere. It's only transfer between two individuals. Society has nothing to do with this. Association has nothing to do with this."
But our the bylaw says it's up to 5,000 rupees is what is charged, and nobody has collected it so far. That's a different story. But it says that 5,000 rupees is something we can collect from each member.
That's what. Yeah.
Okay, fine. Thanks.
Okay. Next, Mr. Samir Mathur.
Yes, sir. I have one question regarding this Karnataka Apartment Act 1972. You told it is a self-governing. Maybe I missed some part of it. Does this mean that there is no authority or any cooperative who is responsible, who is managing this? Just a DOD which is self-sufficient and nothing has to be done. There's no renewal. There's no audit. Nothing. How does the 1972 Act act? It is
Sir,
compared to the cooperative.
what happens is here there is no authority. You are correct. But for residents, obviously, if you are a larger complex, they will ask your audit reports from a chartered accountant and bank statements supporting all those expenditures. So that for that purpose, you do audit.
Is there
if
any
residents
person
wants to know, because it is totally participation process of all residents. If you are not participating, there can be misappropriation of funds. Always, you residents should participate. If they do some criminal activity like misappropriation, yes, you have a remedy, but there is no authority to check into it. You have to go for civil court or magistrate court.
Abhilash, I have a query. 1974 has some rules in that. So 1974, the typical bylaws for 72 has very specific rules of finance on that. Please look at it. It is there in that to do audits, internal audits. So what, as an association, we are also in 72. Every year we do the audits. Every year auditor's name is proposed in the AGM, get it approved by members, and that party does the audit. So there is transparency. People can come and sit in the office and look at the reports or the documents or anything. People means members.
So this is again a self-governance style where you residents participate and in general body meetings and approve the auditor and everything.
Exactly.
So that's what I meant to say. It's self-governance in a way. So there is no government sitting upon your head to appoint a prescribed auditor or anything. Such things are not, demands of governments are not needed to be entertained under 1972.
Sir, I have a sequel question. In case the association is not formed, there are many cases in which they are not signing the documents from the builders, although they are collecting the money. So what is the legal things on these things? Are these associations okay to run without collecting? Former handovers have not happened, but they have started collecting the maintenance and the DODs, everything is registered. So
who has started collecting maintenance? Residents have started collecting maintenance?
Yes. They form the interim committee.
Problem comes only when some resident denies to pay maintenance. Correct? So you are good until all residents are paying. But problem only arrives when resident says that you are not an association, I will not pay, then you have to again go pillar to post running to form an association.
No, but the association is already formed under 1972 by the builder, isn't it? So how does that...
handover takeover, you may have taken operations and maintenance from the builder side. So that part, but the handover of, there are several things you need to change. The ownership of electric meters, common area electric meters in association name. And you need to see also this audit, civil audit process only started, we can trace it back 3 to 4 years back. People, the new apartments which are coming, they are only going for civil audit. But already apartments which are old enough, they did not have the knowledge to go for civil audit, get it done, and then take handover. From nowadays, people are opening their eyes. Yes, before we take handover from the builder, we should ensure that builder has constructed the property without any deviations, obtained licenses of several other these things without any deviations, obtained fire NOC without any deviations. All these things has to be audited. Now people are getting this knowledge. Before taking handover, we should go for audit. Earlier, this was not the practice. So I cannot, it is a case specific. It cannot be...
Yeah, in the older case, I think they have just signed one document that this many documents are handed over, finished.
Correct.
So only received, and it is not a handover process where documents are received. If you go through your files in the old files, you may get one single letter that builder has handed over these documents, finished. That is what is handed over.
No, sir. In this case, what has happened is from the builder side, there was not a deviation. It is mainly some of the landowners were trying to create some ruckus. And that's the reason the residents have been slightly afraid of the landowners' Gundaism, which was there, in which these people, the residents told no. The
No, who is
residents will
collecting
know.
maintenance money? Who is collecting the money, maintenance money?
Residents.
And the landowner is paying or not?
Landowner is not paying.
Then you have a legal remedy
legal
to
case,
file a money
yeah.
recovery suit. Yeah.
I think you should speak to Abhilash separately on this. This is a real issue where many smaller apartments are facing this issue. And yeah. When you are telling residents are claiming, that doesn't tell how that account is opened. No one knows how that account is opened then.
Residents open account based on the DODs and the things like
No,
that. They
that's what
got
I'm telling. Previously, banks were simply opening accounts without much headache. Now it is becoming very difficult to open accounts with only DOD. It goes to NSDL for a PAN. You have a PAN number?
Yes.
Those days it was easily got. Now you don't get PAN numbers easily.
What is the procedure now? They have to get a certificate, or how do they say that we are a formalization? And
that's a different subject. For that, you have to form a
So please
AOP.
contact me after the seminar. I will share my number in the group. Yeah. So yes, Faiz sir.
Yeah, you have few questions. Basically related to this BESCOM. Recently, one of the BESCOM JE came into our society and told, if in case the residents or individual flats delaying the payment, they have the rights to sue into association. Is there anything like that?
If they give any notice,
it's verbal. It is verbal. It is
it's
verbal.
builders. No. It's verbal only. It's builders' responsibility to give individual meters to all owners. You have to argue with the JE that if you are doing, then I will have to file a complaint, lodge the complaint against ombudsman against you. You cannot disturb common area meters. Yeah, if he is not paying, you go take out his fuse and don't give electricity to that person, that flat. Don't disturb the other meters here. You don't have any right to such. If you also threaten him back.
No, the problem is even our common area meters currently, I think in the previous, builder name only, it's not changed into the association.
It's very simple. It's very simple.
Take a NOC from builder. Take a NOC from builder. Get it changed.
Okay.
See,
and
one
this commercial meter, like you said, it's if it is consumption is 25%, then only we need to take the commercial meter.
Yes, if you have a commercial meter, we can get it converted to residential meter and reduce the cost.
Currently, we are running in the residential meter. Do we need to take the commercial meter? That is what I
no need.
Abhilash, I want to clarify one thing here. See, clubhouse, swimming pool, all are used by members. So that to consider for your residential one. If in a bigger apartment, if something you are taking rent,
yeah,
I would suggest look at this as a separate subject, because if you are collecting revenue, then it's a different matter. But if members are using for themselves, clubhouse, gym and all, that should not be considered as commercial. That can be residential. But in bigger apartments, I have seen sauna is there.
We have the rental space, which we given for the supermarket, cafe and all those things.
What is that meter on now?
Currently, it is a residential meter.
Look at it, still 25% is there, fine, but there could be some ambiguity on that where you are taking rent.
I to differ, because let it be clubhouse or let it be any commercial shop or anything, if it is falls under the usage 25% usage of the entire apartment complex, they are entitled for residential meters only. They don't need to go for. You challenge that clause 3.1.1 in this supply of electricity, you will always have a remedy in your favor. No need to worry about that. Okay.
One thing is which is not related to this one. What can we alter our society structure or entrance? What is the rule for that?
Please contact me. I will give detailed solution to you after the seminar.
Okay, okay, fine.
Yeah. Yeah, Mr. Prakash sir, yes, sir.
Again, I just want one clarification. See, if a clubhouse and certain areas are treated with 25% bracket as a residential metering, we came across BWSSP charging these as a commercial places. So how to tackle this?
See, BWSSP, I have not come across any law for water usage, but for electricity, yes, we have a solution. If I come across if any solution available for BWSSP, then I can advise you. But this is only for, I'm only speaking in perspective of rules available in the BESCOM Act.
Okay, okay.
I have not come across rules available in BWSSB Act. If there are any rules that if this used for commercial usage, then you may have to go with that commercial usage only rules.
See, BWCSP doesn't have, they consider even clubhouse, swimming pool, everything as commercial. That is the biggest problem. BAF is trying to fight with them to say that it's personal use, it is not rented out or revenue is not collected. But BESCOM under KARC is very clear, 25% they have given that, and people have to be very clear. Most of the engineers show ignorance, BESCOM people, but if you can show the document, they go back. I know L&T South City has fought with them and got all the penalties waived off.
Okay. Thank you.
Thank you. Any more questions? So I believe I was able to answer many of your questions. So I have left my number in the chat box and also in the Telegram group. Please contact me for any suggestions. I will share my profile personally for anybody who wants to have a look about the scope of services we provide. And Gautam sir will also, you can contact Gautam sir personally on to him or call him. Please leave a message for me on WhatsApp if possible. If you have a want to contact me, I will share all the details.
You can call me, share a message for anything technical issues like these penalties, and because I have gone through all in our apartment, so personal experiences can be shared.
Yes. Thank you very much. I will share this recording on. I will upload this on YouTube channel by end of this day. I will make two parts, one of Gautam sir's part and one my part video. I will share two videos by end of day today. Thank you, everyone.
In one more thing, in the Telegram group, I have put all the 4 licenses departments links. Please go through that and look at it. If anything there, you can just give me a call. But I am not a licensing or any one person. I can only tell how to do it. It has to be done personally by associations.
Yeah.
This Telegram group will be open, or you are going to?
We'll open it for a few 1 or 2 weeks till we upload the YouTube video. So.
And YouTube video will come under which one? What is this one?
Teachers Law College.
Law College, is it? What is it?
Teachers Law College. My YouTube name is Teachers Law College. I run a law college by name Teachers Law College.
Okay.
So under this name, you can just go Google Teachers Law College. You will get YouTube there also.
Okay, and if you can just share your number with us so that in case of any future.
I have shared in Telegram group and I also shared in the chat box here.
Okay, fine.
Please
Thanks.
note down.
Thanks a lot.
If I end this meeting, you will not be able to.
You end it after 5 minutes, Abhilash.
Yeah.
Okay, I'll take it. Thank you, sir. Thank you.
Thank you. Both our numbers are there. My number. 8197371889, and Gautam sir's number is also available. 9900689736.
Thank you, Gautam sir and Abhilash sir. Thank you.
Thank you. Prakash sir, which apartment you are from?
Same as Gautam sir, Liberty Square.
Liberty, okay. Shrikant sir.
Management committee member.
I had a question.
Yes, please.
Am I audible?
Yes.
See, deed of declaration is declared. Then association is functioning. Then there are some commercial establishment comes up. Then should we register under Societies Cooperative Societies Act?
No.
Why? Because it is
you
the
said there is a
document is dependent upon your plan sanction document. Your plan sanction will say residential plan sanction.
How can commercial come later on?
No, they'll start a salon. They'll start a outlet.
That is a bylaw deviation complete afterwards.
Agreed, sir. That's what I'm telling. Let us say it
No,
starts.
it's a deviation. It's a deviation. You cannot do anything.
Agreed. They start. What do I do?
You cannot. You will have to get
I'm
it.
not starting. I'm not starting. One
Exactly.
of the owners starts it. How do I stop him?
BBMP. Complaint to BBMP.
They will come collect money and go. They had started a service apartment here. They came, collected money and went away.
Okay.
Then you need to follow up and file a writ petition, get an order for them to demolish such.
From the association, you have to go legally.
Oh, sir, the whole thing will be big mess.
Then nothing can be done. See, if we cannot fight it, then we'll have to keep quiet.
That's what I'm telling. Those who are subdued will continue to be trampled. Those who are making use of this system will continue to make use.
Association is the strongest entity. If association RWA cannot do it, then no one can do it.
Provided it is manned by all men of virtues. They themselves are running office. One fellow became a president.
You cannot comment on that. See, that we cannot comment on. If association wants, it can be done.
If material come, he will not be ready. He said, sir, I will be ready, get it that. Sir, no.
Anyway, thank you.
Thank you.
Where is it?
Thank you. I will end the meeting. Thank you, everyone. We had wonderful questions.
Yeah, thanks.
Yeah, thank you.